Hey, welcome to Queen City News Plus. We got order in the court today. I'm Brien Blakely.
And I'm Chief Legal Analyst Khalif Rhodes.
Khalif, all right, good to see you. We got three good topics as we always do. Court is in session right now. We're going to be talking about Spirit Airlines, their demise over the weekend, and what's passengers going to be able to do, their legal rights that they have if they've been stranded. And then also NASCAR's got some more feuding back and forth. What's NASCAR? That little feuding with some lawsuits. So we'll break that down. But the first one we want to talk about is SCOTUS jumped in today is about Mifepristone. As people can order that, they're restored access to the abortion pill. Let's go ahead and talk about what happened here.
Brien, you're talking about Mifepristone, you're talking about abortion. So we started at the beginning, Roe v. Wade, constitutional right implemented in this country, 50-plus years of court's precedent, was struck down by the Dobbs decision. At the time, legal experts said that this Dobbs decision would open the floodgates to having litigation, back-to-back types of litigation, and they were accurate. I mean, once you decide that there is no constitutional right and the states can make a determination on an individual basis, who and when and what type of abortion you can have, if any, in their individual states, then you knew that there would be litigation, and that's what we've had. Any type of legislation that's been implemented has been challenged. Any type of rulings that have been implemented has been challenged, and this is nothing different. The Court of Appeals for the 5th District decided to strike down the use of telehealth type of mail-in distribution, and it's worth noting that this case directly impacts drugs used in two-thirds of all abortions in this country. And so limiting telehealth prescriptions and mail-in delivery of mifepristone was major. This wasn't something that was, on the fringe of abortion, 1 or 2%. You're talking about 75% of all U.S. abortions are using that type of drug. And so it sent a crater into that industry, and then you had a number of folks challenge it to the Supreme Court. So the standard when you are attempting to do an injunction is 4 things. It's irreparable harm, it's likelihood of success on the merits, it's the public policy, and it's just weighing up the public interest. And so the court will look at those 4 factors. The biggest one is the irreparable harm. If money can fix it, the court is not likely to grant an injunction. And so you can't fix it with an abortion. You can't say, hey, you didn't get the abortion pills that you wanted. You end up having the child that you didn't want to have, and so now we'll pay you money for that. That's the easiest, elementary school breakdown of that standard. But that's something that the court would look at, and I can guarantee that's what they did here. And remember, this is on the shadow docket. This isn't a full-fledged hearing. This is an emergency
Let's talk
docket.
about that. Shadow docket,
Yeah.
real quick. Just explain that process when a Supreme Court jumps in on these emergency type of situations.
Well,
like
it's
that.
supposed to be where they're taking things that are on an emergency basis and they're making determinations that are temporary. Now, there has been a number of pushback from, Justice Ketanji Brown Jackson and Sotomayor and Kagan that have said, hey, this rendition of the Supreme Court is using the shadow docket for things that it's not supposed to. But historically, the shadow docket has been for emergency basis. You have something that can't wait, can't be delayed, has to be heard right now. The court takes action and then kicks it back to the lower court. That's historically what has occurred. The last few rulings off the shadow docket, because it's not really going to be an order. It's going to say, hey, we rule like this and go back and wait or do something. In this regard, we ruled that we're going to overturn or stay, I should say, the Court of Appeals decision. And because we're staying the Court of Appeals decision, we'll have a full-fledged hearing. It goes back to if nothing occurred with the Court of Appeals until they have a full-fledged hearing. There have been instances with the shadow docket where it hasn't done that, where they have taken action without writing a court of appeals.
This is a temporary ruling here. This is not a permanent ruling. So there's a lot that's going to have to be hashed out before this can go forward in any way.
It will. I mean, and this is going to probably be less about abortion, even though it's an abortion case, and more about administrative law, like who makes the determination of rules. So because obviously you have the FDA versus the courts. This is going to be federal preemptive. Does the federal government have an ability to preempt state law? And you would assume that the court wouldn't rule that way because in the Dobbs decision, they're saying the courts don't want to make this determination, and the states should make that determination. So if they're consistent with their previous rulings, they will say, hey, the states have the ability to do this. So now we have to determine what insight does the FDA prove and provide into this, and what guidance and or regulatory authority do they have. And so this may be an opportunity for this court to weaken another agency's ability to render rulemaking, policy making, and pull that back a step as well.
One of the things too, you have differing laws in states right now when it comes to abortion. Specifically, I mean, North Carolina and South Carolina.
Mm.
South Carolina right now is moving to go to even a more extreme a law where it's almost
A near permanent ban,
new
almost.
permanent ban.
Yep.
Right. So if someone is ordering this in South Carolina, the ordering mifepristone by mail in South Carolina, what could happen with that person? What do they need to know?
Well, it depends. I mean, if you're ordering it from a doctor in another state and it's being sent to you in South Carolina, there are a number of states that are attempting to criminalize that action of it coming from a state that is legal to a state that is illegal. And there is a older law called the Comstock law that hasn't been used, Comstock Act, I should say, that hasn't been used and is rarely used, but that could be used to ban mail abortion drugs nationwide. For being able, that's more of an obscenity type of law that was used in place with adult material years ago, and that's what people are pushing to say, listen, courts, if you want to take it from the states, again, states' rights versus federal preemptive rights, and you want to make sure that we can stop the mail-in aspect of it, you could use this Comstock Act to prevent that. So there are a number of ways that you can get there, but this is big time litigation. Let me put it in perspective. This is like big tobacco coming to the table. Because what do you have? Big pharmacy. Pharmacy companies are warning of regulatory chaos. They're warning of undermining the FDA's scientific authority. And so they're saying, hey, court, step back and allow the states to handle this, and don't allow the Fifth Circuit to do what it did, because now you're stepping on a lot of people's toes.
What kind of time frame are we looking at here?
It depends on how fast they're able to hear an argument. I mean, the fasting already happened. That was the emergency shadow docket, so it could be pushed to the next term, or they could move it up as soon as possible. It really will just depend on the court's decision. I mean, but Justice Alito, who we're looking at there, this is another Louisiana case, right? Hot off the heels of him, authoring the Louisiana decision in the Voting Rights Act. And so this court is wanting to address these types of decisions sooner than later.
Yeah, they definitely want to hit on the hot button issues for sure.
They have not strayed away from it.
Yeah, they definitely do not want to do that. Another hot topic we want to talk about coming up in our next segment before we take a break here. Spirit Airlines folded over the weekend, just went away. A lot of it was rising jet fuel costs. The administration was trying to get something done there with a deal. That didn't happen. So let's talk about passengers' rights and what they have coming up after the break. You're watching Queen City News Plus with Order in the Court, Khalif and Brien. We'll be right back. Welcome back to Order in the Court with Khalif and Brien here, and we are going to be talking about the next segment here. A big story over the weekend, Khalif, and that was Spirit Airlines folded, just went under, trying to come out of their second bankruptcy. And, within hours, thousands of flights have just been canceled, leaving passengers just stranded mid-trip, trying to scramble to rebook. Very little notice here. Let's talk a little bit about the Spirit operations, how this happened, and also what can passengers do?
The writing was on the wall for something like this, obviously, for years. I mean, there was a number of mergers that attempted to occur. I remember most recently with Elizabeth Warren cheering the fact that the Spirit Airlines last merger that they tried was not successful.
With JetBlue, right?
With JetBlue specifically, because she argued at the time that it would raise prices, the merger would raise prices for consumers needing to have a lower tier option. Of Spirit came back at the time saying, hey, well, if we don't have a merger, we're not going to be existing. You talked about two different bankruptcies that have occurred over the years, and this was, again, the writing on the wall with the increase in fuel and other things that were costing them. They haven't made a profit since 2019. And so that was almost 7 years of not being a profitable company. And so you'd have to be blind or had your head under a rock, not looking at what was happening to see that this was something that was coming. In terms of the process, you're talking about they had 4,000 flights scheduled through May 15th. But they also said most recently, as of today, that most of the refunds for those flights have been sent back to customers. But so I think the cause of action would be, I mean, first of all, you can't get what is it, juice from a turnip, right?
Right, right.
If there's nothing there to squeeze, you can get a judgment in hand. It's meaningless. And so, if a person was able to find a cause of action to bring against Spirit, are you going to be able to recover if a court rules in your favor against a company that is insolvent? You know, they're in this liquidation, not restructuring. So they're not trying to go through and, you know, sell off items so that they can rebrand. They're selling off items so they can pay other debtors that would that are the other creditors, I should say, that would have priority over you as a customer, stepping up, not having any type of priority in terms of recovering and recouping some type of debt that's owed to you. And this is straight law school 101. If you're a holder of debt, you want to be a priority holder of debt. So you want to be someone like the federal government having a tax lien, for instance, top tier priority. You want to be someone that has a judgment that's filed, top tier priority. You want to be someone that has it in order in front of someone else so that your priority can be higher. But a person that wins a judgment after all those other folks have already filed their claims, you'll be so far down the loop that it won't be even worth attempting to spend the resources on filing a claim. I mean, but does my heart go out to folks that were stranded over the weekends? It does.
Yeah.
But it also is going to be
And for
hard
the
to
employees,
recover.
thousands of employees who just all of a sudden were told not to come to work, that's your last day.
And that's the other issue that I would have with something like this. When you talk about bringing a claim, it's not just, was the action something that we didn't recognize was going to happen, right? And so, did you cause me injury by a reasonably foreseeable incident? So if I'm saying that the writing was on the wall and you have flights that were scheduled through May 15th, but you just announced this immediate shutdown, how soon did you know? And again, if someone wanted to go through the process of trying to become successful in litigation, how soon they knew, how soon could they have cut it off to and mitigate the damages? Should you have been taking flights to locations where hey, there wasn't a return flight going to be available? Those are some of the questions that would be asked in a potential claim. But yeah, in the bankruptcy claim, they're going to have the weakest argument. They, as in a consumer ticket holder, would have the weakest argument to getting recovery. If, for instance, okay, they caused you to not be able to make your flight back or missed your honeymoon or something like that, it's not going to be recoverable. And even if they weren't insolvent, most of the time they had the common carrier protections, which would say, you didn't contract with me to get you there at a specific time. You contracted with me as the airline to get you there, period. And so I get you from point A to point B. And if I happen to delay it by 10 hours or, 2 days, I fulfilled my end of the contract. And that's always been the airline's argument when people say, hey, well, I want to sue because they didn't get me there at 5 o'clock like the ticket said. Well, the ticket's fine print says we're obligated to get you there, not at that time listed.
Yeah, we knew about this from Spirit Airlines because they were hinting about what was going on. They were hoping the Trump administration was going to step in, and the deal was over the weekend. It gave some a little bit ample time there for people that were flying with Spirit.
Yep.
But still, if you kind of already got it booked, you got it booked. But the deal, apparently, the government was going to try to take over 90% of the company going forward, which is just it was just too much for the people at Spirit to swallow, and so they took the official announcement to go ahead and go to end everything. Refunds, those are for people that purchased directly. If you did have a ticket that was purchased by a third party travel agency like an Expedia or
Yeah.
something like that,
Yeah.
you'll have to contact them. Compensation for customers who used vouchers or credits or loyalty points will be determined later as part of the bankruptcy process.
And that's why I say those folks are so far down the line. If you had a voucher and it was connected to credit, you can pretty much count that as not going to occur. Because remember, in the bankruptcy process, the individual or company that has priority to their debt is going to be the one that takes priority.
Yeah, the
It's in the
loyalty,
name.
it's just the way it is, and then loyalty points, those are worthless right now. So,
Yeah, I mean, and it's even a step further. I mean, in law school, the course for this type of thing would be secure transactions. So when you're looking and taking a class like secure transactions, want to ensure that you have secured your debt, right? And so if I have a debt to you, have I secured it by filing it, by giving proper notice? Okay, a secured debt is going to be even more priority than an unsecured debt. Um, the folks that we're talking about, those are unsecured debts. You purchased it, but it's just money owed to give back to you, not secured by anything else. And so, because of that, the priority is so far down the list. And I mean, yes, a person could ultimately go through the process of attempting to recover vouchers that were credited and now lost, but the cost of doing that would be far exceeding what you would recover.
you talked a little bit about, obviously, the passengers. We mentioned some of the employees, the thousands of employees are pretty much just left without a job, left without, benefits or that sort of thing. They're just kinda high and dry right now. What can they do, if anything, legally going forward?
I mean, it depends on the state. I mean, if they are at will employees, a company would have the ability to terminate you for no cause needed at all. And then if the company is no longer in existence, any type of severance packages that were secured previously, hopefully they were ironclad, and they also would not fall under a secured protected debt that you'd be able to collect, and so you'd fall in after all of the secure folks, you'd be able to jump in line there as well. And so it's going to be a complete um, problem for employees that were recently terminated to try to be made whole from a company that's just insolvent. I mean, this isn't the first company to go out of business. It is definitely one of the first major airlines to be put in a situation where just a perfect storm occurred. And as you mentioned, the bailout was something that folks thought was going to at least save the company for flights and for employees, but it just was unable to occur.
All right, we're gonna leave that one there for Spirit Airlines. Hopefully, those passengers will get things worked out, and also those employees too. Coming up next on Order in the Court, that guy right there, Joe Gibbs Racing, JGR, they're involved in some trade secrets, a lawsuit with that. We'll have more on that coming up after the break. You're watching Queen City News Plus with Quarter in the Court with Khalif and Brien. We'll be right back. Welcome back to Order in the Court with Khalif and Brien. Right now, we are going to have our last segment. We're going to be talking about NASCAR. Trade secrets
Yeah.
being stolen, possibly. And this is a case really here with Joe Gibbs Racing out of Huntersville, JGR, suing former competitor, competition director Chris Gabehart and Mooresville based Spire Motorsports here in late February. Um, for trying to steal some trade secrets impacting the NASCAR results here. What do we know
Well,
about this? What goes on?
oh, this is like ripped right out of a movie headlines. They're talking about look at this. They say this case is really about protecting competitive intelligence in a data-driven sport. I'm laughing when I read this because it was so many instances where like, hey, that sounds like a movie. That sounds like a movie. The individual recognized, hey, I got to this company and they promised me a number of things, and this was said in the hearings. They promised me creative control and a number of opportunities to lead and be in charge. He said ultimately what happens is Gibbs in the team was basically lurking over his shoulder the entire time, and it wasn't any control. It was micromanaged to the point where he believed the relationship started to deteriorate. So he leaves, right? In the process of leaving, and that's what they're saying is they're alleging the trade secrets. He connected his personal email to the company laptops. Additionally, they said that he created a folder on the computer named Spire and did a number of tests on that computer, and then took those tests in that folder with him. He argues that, hey, I created this folder because I recognized the relationship was deteriorating, and I was weighing my options of why I should go and leave here at Gibbs Racing and go to Spire. The other thing I think was interesting is that part of their complaint, they included from the telecast of a race that one of the announcers saying that, hey, Spire seems like they have been, becoming extremely successful since this individual got to their company, and hinting at the likelihood that it's because of something that he acquired while at Joe Gibbs Racing.
Yeah, Carson Hocevar winning Talladega 1 week before the lawsuit was filed, and they're pointing to that race specifically where they got the information and Gabe Hart's information help one of the racers help win.
That's the allegation, but I mean, the fact that they're in Joe Gibbs' team in their complaint and their reason for citing a preliminary injunction is saying that, hey, right on the telecast, they're saying the only reason they're winning the race is because this guy came from our team and is in essence
saying the quiet part out loud.
Right. That is definitely the quiet part out loud. So just like in our other case that we talked about earlier, the judge went through the preliminary injunctive standards already. Likelihood of success from the merits, irreparable harm, the balance of the equities in the public policy. And it goes back to irreparable harm. Joe Gibbs is saying, okay, and this is why the court didn't grant it fully. They denied the injunction against Spire. Why did they deny it? Well, because money could fix it. If you're saying they're stealing our information and they're using it against us to win races, and these races are going to come with purses, right? Well, you can fix that by getting the money back that they got from you or by properly acquiring or winning these races by using your information. However, the court did partially grant Joe Gibbs Racing's relief with must stop using trade secrets, must return all materials, and cannot perform the same role or functions that Gabe Hart had while at Joe Gibbs Racing. So they're saying even after the judge granted that preliminary injunction, he's already violating. Why? Because he's circumventing the restrictions, observing live races from the pit areas, potentially real-time advertising. And those are the types of things that they're saying, hey, judge, you granted this, but now they're not even doing what you said that they should.
Mm-hmm.
So this one is going to be a lot of back and forth. But for me, the most damaging part is going to be the folder, because that forensic trail of evidence is going to be hard to defeat, right? If you create a folder with the new name of the company that you're going to on your old work computer, and then you've done these simulations and these tests on the work computer, and if you're taking these files from the company, the trail of breadcrumbs will be there for them to say, hey.
Well, what happens then? What's the penalty?
Well, I mean, if you're if they can point to use of their trade secrets, their data that they've created over years to make their vehicles perform faster, and now this other company is now utilizing it to win, i.e. in that most recent race that you talked about, I mean, there could be a number of things that the court can implement for sure. Return. I mean, you can point to any profits that they gained from that, and you could say, hey, from the day he got here, if they were finishing dead last and now they're finishing 15th, I want to be able to recover all of those amounts, and I can directly connect it to his, taking of our trade secrets. That is going to be hard to prove. It will. But there are a number of things, at least from this early reading of this, that seems that it's going to be easier to prove than I suspected when I first started reading this, which is, again, spy type of drama, that there's proprietary data and if you're using these simulated models to create and take information to another company and using Joe Gibbs Racing's data to do it, that's going to be the nail in the coffin. If they can point to multiple instances of that, unless he has a reason for it,
so is it a big monetary fine?
It won't be a big monetary fine. I think it's not just a fine. It's going to be a return of those proceeds. And so if they can put
take the win away,
I don't know about taking the win, because that would be more NASCAR.
Yeah,
but it would definitely be more money. On the court's perspective, it would say, if you can point to a date in time where he arrived and a connection to the winning, right? So go back as long as they've been around. Have they been winning these types of races, right? And then part of it will be, in his argument, well, this is what I bring to the table. Me, my mindset. I didn't take proprietary information. They're winning because of what I brought to the table. Not your trade secrets, but yet my own abilities that I wanted to use when I was working for Joe Gibbs Racing, but you guys didn't let me. So there will be multiple arguments. They're seeking $8 million in damages, misappropriation of trade secrets, breach of contract, misconduct. These claims are definitely nothing to laugh about. But again, reading it ripped straight from a novel.
I love it. And maybe a movie someday. Always good stuff with NASCAR, and always good stuff with you, Khalif. Especially appreciate it. That's going to wrap it up here for Order of the Court. Court is out of session right now. We're going to send you back to Queen City News Plus.
Queen City News Plus. Just search Queen City News on your smart TV's app store.